We'll have everybody place their appearances on the record, starting with the District Attorney's table.
Tony Jordan, District Attorney on behalf of Washington County.
Christian Morris, Chief Assistant District Attorney.
Kurt Mostert, Attorney for Kevin Monahan.
And can you please place your name on the record, sir?
Kevin Daniel Monahan,
All right, and what's your date of birth?
10/28/57.
Okay. All right, and we're here today, Attorney Mauser, pursuant to your application for bail. Anything to address before we get started?
Nothing, Your Honor.
No. Okay, go ahead, Attorney Mauser.
Judge, New York has reformed its bail laws, and two essential elements of the new bail laws are that a bail for a qualifying offense, which we all agree murder in the second degree is a qualifying offense, should not be imposed in a manner so as to cause undue hardship to the person who needs to post the bail. In addition, the purpose of bail, the sole purpose of bail, is to ensure a defendant's return and participation in the criminal proceedings. It's not to be used as preventive detention, and it shouldn't be used so here. My client is a resident for more than 30 years of Washington County and Hebron. My understanding is he has no penal law convictions. My further understanding is he owns his own construction business as a builder, and he has significant ties to the community and no ties to other communities. He owns his own home here. He owns a house in Warren County, which is in various stages of renovation. But the roots in this community for him and his wife run deep, and there are no roots anywhere else. My client will come to these proceedings. He called me the night this all happened. He will voluntarily participate. Bail is not required, but I understand due to the severity of the offense, the court will probably entertain some sort of cash or monetary bail. I would ask that it be reasonable, not be unduly harsh, and it be the least restrictive to ensure my client's return to these proceedings.
Thank you.
Thank you, Judge. Yes, there's been reforms to the bail law, and in 51030 of the CPL, there's some criteria for the court to consider, which I'd like to go through if I may, because on a bail-eligible offense, in due consideration of these factors, the court may set bail or may remand without bail, as the case may be, to secure the defendant's return. 51030, subsection 1, I'm going to go through the further subsections that are lettered. Subsection A is the principal's activity in history. From the very beginning of this case, our office has received, and the media has reported, the defendant's character and reputation in the community. It is one of being confrontational and hot-tempered. This describes a certain level of impulsiveness in his character, which in the light of considering flight risk weighs in favor of someone fleeing, as flight is usually impulsive in nature. So that's something to consider as someone who's very hot-tempered and compulsive. In this regard, I would point out just last week in this very building at the Department of Motor Vehicles, the defendant caused a scene for having to be required to set an appointment, ended up taking photographs of the workers in this building and stormed off. Subsection B, the charges that the defendant faces, as the court is aware, murder in the second degree, is a Class A violent felony, which is the state's highest charge, which means it comes with the state's highest sentencing if found convicted. But given the facts of this case, which based on the charge that the court is aware of with the motion made by counsel, is some young adults were traveling in the Hebron area where they turned into the wrong driveway. They were at the defendant's property for a very short period of time. When they were fired at, one was shot and killed. There's other charges that could be filed that the court should consider. It's not just that it's murder in the second degree, but other charges which could be filed and are being considered are attempted murder in the second degree for the other individuals that were in the car, attempted assault in the first degree, and criminal possession of a weapon in the third degree, all of which are bail-eligible charges. There are other non-qualifying bail charges as felonies which could be charged, although they're not here. What's significant in the murder second charge relative to sentencing is that the minimum is 15 to life, maximum 25 to life, which means, as the defendant sits here today, if convicted and sentenced even to minimum, he'd be 80 years old before he was released, potentially 90 or greater. So in essence, this could be the last free day he has. And that's a huge factor to consider for flight risk. On top of that, if you compound that with the media presence here, which is not normal for our community, someone under the spotlight of national and, in this case, even international media poses another factor from which flight could be drawn. And here, nationally, in the recent years, we've seen a number of cases where people who are under the spotlight of the scrutiny and a murder charge flee. Criminal history. Counsel has said that he has no penal law criminal history, which is telling because he does have a criminal history. He has a misdemeanor, albeit 1980, but he does have a criminal history. In 2001, he was charged with aggravated assault with a weapon in Vermont, which in New York would be a Class D violent felony. So not having ties to another community is also in question here, as this was in Vermont. It was ultimately dismissed in 2002, but in light of the charges he faces here is a significant factor to consider. Relative to his financial means, he owns his own home here in Washington County. The incident, at the place where the incident took place, taking a look into that property, it is owned outright, no mortgage on it. It has an assessed value of $250,000. Counsel says he owns a business. A check of the county records reveal there's no DBA filed. Check of the state records, there's no LLC filed on behalf of Kevin Monahan. He's self-employed as a contractor. That's a significant factor to consider in being transparent for his return to this court. Padding a resume to get out, it doesn't look good in light of the charges he faces. The last two factors for the court to consider is the history or use of a firearm. The state in the bail reform wants the court to consider that as a factor when considering the least restrictive means of someone's return to this court. And in this case, a shotgun was used. So that makes it the highest level when you consider the uses. He's using firearms in the nature of this crime. And the last one is serious harm to an individual or group. And in this case, there's no greater harm than murder of an individual, which is what occurred here. And again, in light of the charges that I mentioned, that could be for the passengers, there's a significant harm that was to them. So when you take all of that into consideration, I think there poses a serious and inherent flight risk by the defendant, and I would ask that he be remanded without bail pending this. However, in spite of all these factors, if the court were inclined to set bail, I believe the least restrictive means, given his financial ability that we've seen, it would, low financial means would be low bail, high financial means, the court would be able to consider a higher financial bail. Here he has significant means that works in two ways: significant means to leave or significant means to return to court. And I'm asking the court in the alternative to consider $250,000 cash bail, $500,000 secured bond, or in the partially secured bond category with 10% down, $1 million. I would ask that if that is the case, given the nature of this crime and the factors that I've set forth, that would be with GPS monitoring through Washington County's Alternative Sentencing Department. Thank you.
And just to follow up on the GPS monitoring issue, I do have some experience in working with alternative sentencing about what options are available. I don't know that GPS would be available out in Hebron, and I think if we were looking at some type of house arrest component with cash, bail, or bond, do you know what type of phone line your client has, Attorney Mauser? Does he have a Verizon landline? Does he have Spectrum?
Consumer cellular.
Okay, so there wouldn't really be an option for there to be some type of house arrest based off of a phone line. Do you want to address that in any more detail?
Well, if this is the route the court is considering, I would ask that at least there be an assessment made prior to any release on a bail amount by alternative sentencing to see what is the best fit that they have for that property. I understand that they can use cellular service for some ankle monitors, maybe not GPS, but some ankle monitoring can be used through cellular service.
Okay. Attorney Mauser, would you like to respond?
Judge, I do want to respond. I don't believe the bail statutes ask that the court take into consideration rumors and innuendo. But even if we accept for the sake of argument that these rumors about my client being hot-tempered are true, why doesn't that show up on his criminal record? The people are referring to a DWI conviction under the vehicle and traffic law that's 43 years old, when my client was 22. Really? Ancient history of a 22-year-old kid is now gonna be used to try to influence this court to impose exceedingly high bail? The fact is, my client has no penal law convictions. And if we're gonna start talking about records of criminal arrests that are sealed by means of a dismissal, is Vermont so incompetent that they let a guilty man go? No, maybe my client got arrested in Vermont, but the case was dismissed. There's gotta be a reason for that. Perhaps my client was innocent. So that's not a factor for the court to consider either. And as far as having a fit of pique at the DMV and not getting along with DMV, God forbid that's a bail factor, because the whole state will get locked up. Who among us have not had the pleasant experience of going to DMV and not having a good time? So a rumored argument at DMV, a rumored bad experience at DMV is now a bail factor? Everybody in the state has bad experiences at DMV. That's ridiculous. Other charges? Okay, yeah, there are possible other charges. Where are they? They're not here. They haven't been filed. They're not before this court. They're not a factor. My client's self-employed. I'm self-employed. I don't have a DBA. I'm not an LLC. I didn't pad his resume. I told this court that he owns his own business. He does. There's no legal requirement that a business owner has to have a DBA or has to have an LLC. My client didn't misrepresent his resume, nor did I. That's not a factor. It's not a flight factor. Yes, a firearm is used, that's a factor, but the idea of remand, it violates the legislature's intent for the least restrictive means to ensure his appearance, and the request for $250,000 cash, $500,000 bond, and $1 million in partially secured bond violates the legislature's intent that the court not impose bail that will inflict undue hardship upon the defendant. Rumors aside, innuendo aside, character smears without a basis, I might add, aside, we have a man who does own his own business, who's a building contractor, who's lived in our community for 30+ years. And during all that time, he's never been arrested in this state or convicted. All they have is a 43-year-old DWI conviction from a 22-year-old kid to prove my guy's a flight risk. That's just not enough. This court should follow the spirit and the letter of the new bail reform and impose the least restrictive means and impose bail in a reasonable amount that does not inflict an unreasonable hardship on my client and his wife. I suggest that if the court's going to impose bail rather than release on recognizance, bail in the amount of $10,000, $20,000, $50,000, $10,000 cash, $20,000 bond, $50,000 partially secured bond is going to be sufficient. My client will happily turn in his passport, by the way. He has a passport, he'll happily surrender that as a condition of bail.
Does your client have any brothers, sisters, parents in the area?
I have family, yeah.
What
I've
type?
got sisters and brothers. And my father was one of 17,
Okay.
so there's a few of us around.
Been on vacation anywhere in the last 5 years?
Me, yeah, we go to Florida a couple times a year.
Okay, out of the country?
Oh, no,
Okay.
no.
All right. Attorney Morris, anything you want to add?
No, unless there's any further questions by the court.
Okay.
Same, Your Honor.
All right. So the court must decide what the least restrictive alternative is to reasonably assure the defendant's return to court. In making this determination, the court relies upon the factors set forth in Criminal Procedure Law, Section 51030, like was mentioned by the people. Here, the defendant does face a significant term of incarceration for the single charge that he's charged with right now, We don't really know what he's ultimately going to be charged with. We'll have to wait until the indictment to see what that is. But the exposure here is pretty large. It could be from 15 years to 25 years to life imprisonment. I mean, that's the time frame that we're talking about here. And when I look at the bail statute, I'm referencing that under section B, the charges facing the principal. I'm specifically, Attorney Mausert, though, mentioning that I'm not taking into account the history of the defendant, those issues. I'm not considering those in my bail determination here today, okay? And also, your client doesn't have any criminal convictions, so I'm not going to consider that. But we also do have the two new factors that are in the bail statute, which is the defendant's history of use or possession of a firearm. And here, the defendant is alleged to have used a firearm. And then to follow up on the last factor, the defendant is alleged to have caused serious harm. And I use the term serious harm because that's the language used in the statute. But we know from the charge here, what's being alleged is actually that Kaylin Gillis, she was killed. She's dead. I don't think there's any more serious harm than that. So I think that my determination is in the spirit of the statute, and I do find at this time the defendant should be remanded to the custody of the Sheriff's Department without bail, and I find that this is the least restrictive alternative in this case. Of course, Attorney Mausert, you're an experienced attorney. You know that you can file an appeal and go to the appellate division on that. And as the case moves forward, you can make new applications for bail, but that's the court's decision for now, okay? Anything else we need to address?
No, Your Honor, thank you.
No, Your Honor, thank you.
Okay, sir, you're remanded to the custody of the Sheriff's Department, okay?